Good morning. Namaste. Welcome to 148th episode of AAA Weekly Webinar Series. At the fag end of January and in the first week of February, IBBI has released many regulations and also a discussion paper. Although we had a planning to have this part 2 of cross-border insolvency, then we have also planned group on insolvency. But because of this, two things. One, that the international valuation standards were modified, and that was very important for all valuers and all insolvency professionals and also stakeholders. What is the impact on the valuation process for insolvency cases? So therefore, we gave preference to international valuation standards modification in the last episode, which is 147th episode. Part 2 of cross-border insolvency, which is a detailed analysis of US CIRP, the standard bylaws for cross-border insolvency, clause-by-clause discussion. But today, we have given the priority to regulations notified and also the release of a discussion paper. In fact, the discussion paper is very important. So there is also a detailed amendment in the information utility regulations. Since the paucity of time, we have planned that a complete revised regulations of information utilities that would be covered in a separate webinar. So today we are focusing on the regulations, all regulations other than information utility and also the discussion papers. So see friends, I hope this is okay. And as we have got the feedback that we would be sharing our PPT also. So therefore we are in fact sharing our PPT, and this would be our weekly webinar series 148th. And what we are totally discussing today is the CIRP regulations dated 3rd of February 2025, then liquidation process regulations amendments dated 29th January 25, voluntary liquidation process regulations amendment dated 29th of January 2025, grievance and compliant handling process regulations dated 29th January 2025, model bylaws and governing body of IPA regulations dated 29th of January 2025, amendment in IU technical standards dated 29th of January 25 that we are not discussing today, and we will be presenting it before our audience as a complete IU webinar, which will have the modified regulation. Then the discussion paper, which is very important for streamlining the processes under the code, that is dated 4th of February 25. So this is what is our agenda today. Now coming to the first regulation, that is the CIRP regulations. The CIRP regulations, the one difficulty that they were facing, the IBBI was getting feedback that in real estate cases, the resolution professionals are not able to hand over possession of the plots, apartments, or their units, and homeowners, in fact, wait till the resolution processes are completed. This is what the feedback was given to IBBI by many. And even if the flats are completed, even if they're ready for occupation, this was not possible as per law. However, as per practice, in fact, we have, in one of our case, we have handed over more than 600 flats during CIRP. Part of that was earlier constructed, and in fact, the major part was completed during CIRP. So that was that was the precedence that we had fixed. We have already done. We have handed over about 600 flats to home buyers. However, the amendments have now been done in the regulations, and it is also subject to the approval of committee of creditors by 66% voting, and also in case the home buyers have fulfilled all their obligations as per the builder buyer agreement or any subsequent document or instrument that they have executed. So the regulation for capital E has been inserted in the CIRP regulation, which says after obtaining the approval from the committee of creditors, that means the first condition is the committee of creditors, and that is not less than 66% of the total votes. The resolution professional shall hand over the possession of the plots, apartments, or buildings, or any instrument agreed to be transferred under the real estate project and facilitate a registration where the allottee has request for the same and has performed his part under the agreement. So this covers handing over the possession of the plot, apartment, or building. However, also and any instrument agreed. Now, the instrument agreed could be sale deed, could be agreement to sell, which is to be registered, and also it says that the and facilitate registration. Now, when we talk about facilitating registration, this is something which is still confusing in some cases, because see, like when we also say that the regulatory authority, as per the RERA, in all the cases there is a regulatory authority, and that regulatory authority would not facilitate the registration of the plots or the apartments or the building in favor of the apartment. What exactly these regulations are providing now? What exactly these regulations are providing now? That without seeking NOC from the financial creditors, the possession can be given and also the registration can be done. So now, once this regulation has been notified, I believe in many cases where the because of the NOC, which was the requirement to be obtained from the secured financial creditors, in case non-availability of NOC, that would not be a hurdle in a registration of the properties, flats in favor of the allottees, in favor of the home buyers. This is something which is a welcome button. We have been doing this, and we have also got, in the case of Nagpal, in Ramnath developers, a case of Nagpur, and even the NCLT has given us the order that you, in fact, they have directed us that you facilitate registration of the completed units in favor of the home buyers. And now this amendment, in fact, is welcome amendment, and also it is also being done practically in many other cases. So the two things which are still confusing: one, facilitating registration, and two, any instruments. Like in case we have to give an instrument or agree or execute any instrument, that also has to be given to the home buyers. And for that, the 66% voting of the committee of creditors would be required, and the allottee has requested for the same and has performed his part under the agreement. So the requirement: one, COC a vote, 66%. Two, possession, in fact, can be given only in case the properties are worth habitation and it is safe and the fire safety is available, and even in some cases occupation certificate is also required from the real estate regulatory authorities. So all these conditions are in any case has to be fulfilled. Although the regulations doesn't say that, it also doesn't say even if technically possible or if the regulatory authority permits that. So the permission of the regulatory authority is left open for litigation, or it is left open for even the understanding of the buyers and sellers. And also it has to be on the request of the home buyer. Now, the second amendment, which I think that it is also something that we have started right from the day one when we were the RP of Amarpali Group. So we, in fact, have appointed observers. And those observers were participating into the COC meeting as observers without having any voting power. But now the IBBI, actually based on the feedback, has also inserted this regulation, and they're saying that there is no provision for subclass facilitators in large creditors like home buyers. Communication between creditors and their authorized representatives are inefficient. Now, the amended provisions, what it says, in case the home buyers or the subclass of creditors, their numbers are more than 1,000, then the COC may appoint facilitator for a subclass within a creditors class, and that creditors class can be debenture holder, that creditors class can be even for depositors, public depositors, that creditors class can be home buyers, and that creditors class even can be operational creditors in case they have like more than 10% of the outstanding, but they have only a right to be invited. But yes, the class of creditors, debenture holders, public deposits, and in case the unsecured financial creditors are more than 10, that also becomes a class in apart. However, this particular insertion of the regulation is restricted to where that particular subclass has 1,000 creditors, and the maximum 5 facilitators can be appointed, and the facilitators will also receive 20% of the fee specified for the authorized representative. Now, for a case where the class of creditors, the numbers are more than 1,000, then in that case, the fee for a authorized representative is 50,000 rupees for attending one COC meeting. So this facilitator, all these facilitators collectively get 50,000 rupees, and one facilitator can get 20% of the fee of the authorized representative. So I have seen the fee of the authorized representative, that is 50,000 rupees as per the regulation, where the numbers in that class of creditor is more than 1,000. So the exact regulation which is being inserted here, I will read: where the number of creditors in a class exceeds 1,000, that's the first condition. The committee may direct the IRP or the RP, as the case may be, to appoint an insolvency professional other than the IRP and the RP and the AR. So there has to be, first of all, who can be facilitator? The facilitator can only be an IP, insolvency professional. So this can be another opportunity for the IPs. They can become facilitators in real estate cases if the number of claims from a class of creditor is more than 1,000. Then the insolvency professional can be appointed. See, like it's to appoint an insolvency professional other than IRP, RP, and authorized representative, or any other person. Or any other person means the even other than insolvency professionals can also be appointed, or any other person as facilitator for a subclass within the creditors in a class, subject to following conditions. See, first of all, it is written to appoint an insolvency professional other than the IRP, RP, and authorized representative, comma, or any other person. That means we can appoint an IP, or we can appoint any other person, even the a leader from the group of home buyers, a president of their society, or nominee of their association. They can also be appointed as, because it is written any other person, they can also become facilitator for a subclass within the creditors class, subject to following conditions. Now, the conditions are: the appointment of facilitator shall be considered only if, after the first meeting of the creditors, a subclass comprising of at least 100 creditors out of the total number of the creditors in a class request for inclusion of agenda for such appointment along with the name of the proposed facilitator. At least 100 creditors will propose a name, then that particular name will be subject to the COC approval. The total number of facilitators shall not exceed 5. The fee, as I said, that the 20%, that means 10,000 rupees per COC meeting. Then the committee may even replace the facilitator on the recommendations of the majority of the members of the subclass. So on the recommendations of a majority of the members of a subclass. So that means total can be appointed as 5. The requisition for appointment of a facilitator is required at least from 100 members, Then only that person can be appointed. And the committee of creditors, in any case, first of all, the committee of creditors will direct the IRP to appoint facilitators for a subclass. However, the request can come from at least 100 creditors or more out of the total creditors. Then only that person can be appointed, and it included in the agenda for such appointment with the name of the proposed facilitator. So this is where I'm trying to say that they have also set the role and responsibilities of the facilitator. Earlier position that there is no specific role because there was no provision for facilitators. The creditors in class such as home buyer was represented by an authorized representative in COC meeting, and of course there are feedback that there are communication gaps which existed between the creditors and the committee of creditors and the RP, and even between the creditors and the authorized representative. So therefore, this particular amendment, which says that as I said, that this would be over and above the authorized representative. This would be over and above the authorized representative, and the appointment is subject to these conditions. So this is considered to be the roles and responsibilities as per Regulation 16, capital D, which is inserted to facilitate communication between the authorized representative and the creditors of that subclass. Attending the meetings of the credit committee as observer to facilitate communication between creditors of the respective subclass. So there is a subclass now, the subclass within the class of creditors, and each class can be represented by a facilitator. Now that subclass should at least have 100 members. So this is what is the exact law. First of all is a class of creditor where the AR is appointed. Then there is a subclass within the class of creditors where the facilitators can be appointed. The AR will get 50,000 rupees for attending a meeting, whereas the facilitator will get 10,000 rupees for attending a meeting. So if there are 5 subclasses, then there will be 5 facilitators, and everyone will get 10,000 rupees each for attending a meeting, and the AR will get 50,000 rupees. So 1 lakh of rupees is an expenditure for one COC meeting other than the cost of the RP. So this is where the communication gap to be filled up. So then the facilitation would be providing information and clarification to the creditors in a subclass about the insolvency resolution process as per the advice of the AR. So it is also mentioned that these facilitators will work under the advice of AR. Facilitators will work under the advice of AR. Any other task assigned by the committee to improve representation and communication. So these facilitators are working under the committee of creditors. The committee of creditors can assign tasks to them. They would also be working as per the advice of AR. They would be talking and protecting about the interests of their subgroups, subclass, and they would be attending the COC meetings. They would be getting 10,000 rupees as fee for attending one COC meeting. So this is what is the provision for facilitator. So now the IBBA have in fact proposed that there can be subclasses within a class of creditors, subclass within a class of creditors. So though this is absolutely okay, but then as far as we have practiced appointment of observers. We have practiced the leaders of the associations are appointed as the observers, or of course with the permission and with the approval of committee of creditors by voting. This is what we've been doing in all the 25 real estate cases that we have handled so far, and we have seen success because of this, covering up the gap between in the communication between RP and other creditors, committee of creditors, and home buyers. That we have already bridged. IBBI has now made it a law, which probably they have picked up from the traditions. Coming to the next amendment, which is amendment in the Regulation 18.4, Regulation 18 sub-regulation 4, where the corporate debtor has any real estate project. So that means that this regulation, sub-regulation 4, is only applicable to real estate project. The committee may direct the resolution professional to invite the competent authority as defined in Clause P of Section 2 of RERA related to such project to attend such meeting of the committee. So that particular competent authority should be related to this project, as the committee may decide without voting rights for providing inputs on matters associated with the development of such project. And now, in case, see, like I would say that this is something which is important, and then we can even see what is the definition of competent authority under RERA. Because see, the subsection 2, clause P has been referred in this regulation, and then I checked up the definition of competent authority, and it is defined as the local authority or any authority created or established under any law for the time being enforced by the appropriate government, which exercises the authority over land under its jurisdiction and has powers to give permission for development of such property. So in this particular definition, I saw two things: local authority. Then I saw the definition of local authority includes municipal corporations, municipalities, development authorities, urban local bodies, and other similar statutory bodies governing land use and development. Then is any other authority created or established under any law. So that means that may include agencies like state town planning department, metropolitan development authorities, or even housing board that have legal jurisdiction over real estate developments, and also what kind of powers that particular authority will have, so that it comes under the definition of competent authority. So that authority will have the power of granting permissions for land development, approving building plans and layout plans, ensuring compliances with zoning laws and land use regulations, overseeing infrastructure development in real estate projects. So I could see various such bodies, which now the IBBI is saying that you invite the competent authority to the COC meeting, seek information from them, provide information to them, take their consent, and try to resolve the issues regarding the various outstanding dues. That can be various even technical issues, various renewals and permissions. Now, the examples of various competent authorities that I could think about, like there can be something like in Bangalore, there can be BBMP, then there can be Municipal Corporation of Greater Mumbai, there can be Delhi Development Authority, there can be Bangalore Development Authority, there can be any kind of town and country planning departments of every state. Then there can be state housing board like Haryana Housing Board or Maharashtra Housing and Area Development Authority, MAHADA. So all these are the various authorities which actually would now be invited to the COC meetings to understand their perspective, to seek their cooperation and coordination between them. So that's where we actually, this is also like, in fact, I was also part of giving these feedbacks to IBPI, And I was also called and I was also interviewed to understand the real estate projects. So this is what it was discussed, and I think this is also a kind of the process is going towards a mediation process as far as the landowners are concerned, regulatory authorities are concerned, competent authorities are concerned. So this process is towards mediation type. Then we have another regulation 30 capital C, which has been inserted in CIRP regulations, that is regarding report on status of development rights and permissions of real estate projects. The present situation is that when the IM is issued, the RP would not have any information regarding the developmental rights, the approvals, various permissions and licenses, and that kind of clarity is not provided either to COC or to the prospective resolution applicant. Now, the amended provisions are that the RP must prepare a detailed report on the status of the developmental rights or the permissions of the real estate project within 60 days of commencement of CIRP, and that report must include the development right status, approval and permissions required, and also that has to be, even that is required to be submitted to NCLT. Now let me read the proposed regulation that says that where the corporate debtor has any real estate project, the resolution professional shall. So it is mandatory because it is shall prepare a report detailing the status of development rights and permissions required for development of such project, and submit a report to the committee for its comments, and then submit to the NCLT adjudicating authority the reports referred to in clause A along with the comments given by the committee of creditors on or before the 60th day from the insolvency commencement date. So this is what is the regulation which is inserted. Reason for amendment, like this actually will provide kind of help to the prospective resolution applicants in understanding the viability, technical viability, the timelines, and it will improve the decision making of the PRAs and also the COC. It will enhance transparency and the accountability. Now, I have already said that what is the fee of the facilitators, that of course we should not repeat. So most of the amendments are pertaining to real estate, handing over the possession, facilitating registration, inviting the competent authority under RERA to the COC meetings. So, and then all the status of the project. So the difficulties, in fact, this particular regulation amendment should be called specifically for real estate difficulties. And the other regulation 36A, which is the regulation for invitation for expression of interest. So so now there is a requirement that the mandatory requirement of disclosing the MSME registration status and also the relaxation for the real estate allottees. Now, the relaxation for real estate allottees is something that we've been doing. MSME registration disclosure that we've been doing in all our cases. So now they have made a regulation, and in that regulation, they have added a few other information which will be provided to the prospective resolution applicants. And the first information is provide details of the corporate debtors registration status as MSME registration, whether this company is MSME or not. If yes, by what kind of certificate or registration number. That information has to be provided when we are inviting expression of interest for submission of resolution plan. Then again, there is a proviso which is added to it. Then where the corporate debtor has any real estate project, the committee for an association or group of allottees in such real estate projects representing not less than 10% or 100 creditors out of the total number of creditors in a class, whichever is lower, may relax the following. First of all, it should be a real estate project. Second, a group or an association should have at least 10% of the total creditors or 100, whichever is less. They are entitled to some relaxation subject to the COC approval, and that, of course, the committee can approve one, the eligibility criteria. Normally, for a real estate company, we actually say stipulated criteria that the prospective resolution applicant should have some experience of handing over the completed projects or delivering the residential flats or having some net worth. So all this may not be applicable, or the association of a lottery may not be able to do this. So therefore, that concession may be provided to the association of lottery regarding the eligibility criteria. It can be a criteria of having some net worth, some kind of turnover, some kind of like kind of quantitative achievements like handing over experience of handing over some flats, residential or commercial. So those kind of eligibilities can be relaxed to an association of a lottery or a group of home buyers or a group of creditors. So also the conditions regarding refundable deposit, like normally we seek refundable deposits uh, for submission of an expression of interest. In case we don't do that, there can be many people who would be interested in submitting the expression of interest only for seeking information and just the kind of updating their database. So therefore, we seek the earnest money deposit, which is refundable. So this is also a kind of, although we've been doing it, but this is now stipulated that the RP shall do it. That's also a kind of welcome for the real estate project. And the next amendment, which again for real estate project, is the RFRP. When the RP is issuing RFRP, request for resolution plans, and the regulation 4A has been inserted, which says the proviso has been inserted, which says that provided that where the corporate debtor has any real estate project, the committee may relax the requirement to provide for performance security for an association or group of entities in such estate real estate project representing not less than 10% or 100. So again, the same 10% or 100, but now the relaxation is for providing performance security. Normally, the performance security is provided by the successful resolution applicant whose resolution plan has been approved by the committee of creditors, and he would provide the stipulated performance security. That can be a bank guarantee, that can be some upfront amount, and that can be anything which is stipulated as per the RFRP, that will have to be provided by the person whose resolution plan has been approved by the creditors, and that has to be submitted, that has to be complied with before the RP can submit the resolution plan to NCLT. So that also can be relaxed. The only condition is that it should be a real estate project and it should be an association of a lottery or home buyers, and that again 10% and 100 limit is already there. Now the other amendment which is also very important is regarding the Regulation 38, which talks about mandatory contents of the resolution plan. So far, Regulation 38 provides for the mechanism, which is the mechanism for implementation and supervision of the resolution plan implementation. However, no structured monitoring committee was mandated, and there was no requirement for periodic reporting to the adjudicating authority as per law. And once the resolution plan was approved, there was no formal mechanism. Therefore, then in practice, the monitoring committee is being established. However, the progress report conditions were not there. Secondly, it was earlier the word used was the committee may consider. Now this may has been replaced with shall. It has become a mandatory condition that the committee shall consider the requirement of implementation, having a monitoring committee, and the COC must consider. Now it is the COC must consider forming a monitoring committee to over implementation. Now the committee may include RP as the COC representative and the resolution applicants. Quarterly progress reports must be submitted to the adjudicating authority, and it is also mentioned earlier as well as now that the fee of the RP, who is part of the monitoring committee, cannot exceed the fee that he has been charging as RP. So this is what is the amendment. So in case we say, I'm reading the amendment with the amended regulation, the committee shall consider setting up a monitoring committee for monitoring and supervising the implementation of the resolution plans. The monitoring committee may consist of the resolution professional or any other IP representatives of the committee or representatives of the resolution applicant, provided that with the RP is proposed to be the part of monitoring committee, the monthly fee payable to him shall not exceed the monthly fee received by him during the CIRP. The monitoring committee shall submit quarterly reports to the adjudicating authority regarding the status of the implementation of the resolution plan. So this again, the last amendment is the Form G that we are publishing. In that Form G, we also have to talk about the status of the MSME registration of the company for which we are inviting resolution plans. That for Form G, they have amended Form G and they have added one row to provide information about MSME registration. That's also like kind of an encouragement. So this is what we have in the CIRP regulations. Now, quickly we go through the regulation. The liquidation process regulations have also been changed. And we would immediately see, one, there was a gap. There was a gap. Two things. One, there was a process of closure of the liquidation process in case the company has been sold as a going concern. Very recently, in the case of Birla Kotsin India Limited, in fact, where I was the RP, and I was I was not the RP, I was the liquidator. And during liquidation, Section 230 of the Companies Act, a scheme of compromise and arrangement was received. It was approved by the Committee of Creditors. It was approved by all the creditors, and finally, it was approved by the NCLT. That was the first case in India where a scheme of compromise or arrangement has been approved by NCLT so far. Although the attempts were made by many, but this was the first scheme, although with a lot of hurdles, although with a lot of objections from Bombay Stock Exchange and the other parties. But yes, finally it was approved. And when it was approved, it has become a success story. However, it was not clear once the scheme is approved how to close the liquidation process. So therefore, this amendment has come that the liquidation process can be closed. The liquidator will continue. The liquidator will continue till the time all the formalities, the Form H is not submitted. So therefore, when we actually see Form H, the distribution to the financial creditors has to be a part of that Form H. So therefore, the liquidator will continue till the scheme is implemented, till the amount is paid to the creditors, so that the liquidator will continue as a liquidator, and also in case there is a monitoring committee in that scheme, will continue as a monitoring committee also. So this is also a kind of a gap which was covered, that the liquidation process will be closed the similar way as it was being done for the sale of the corporate debtor as a going concern during liquidation. Although there is a discussion paper now which says that this sale of the corporate debtor as a going concern should be completely deleted from the statute. Then we also have the corporate liquidation account. It's like something that I can brief about it. In fact, there was a committee. There was a committee which was set up by IPBI or MCA, which was in fact the mandate was to understand about the corporate liquidation account, which is maintained by IBBI, and it was also provided in the earlier regulation that the IBBI will maintain this corporate liquidation account and will operate as part of the public accounts of India, and shall operate as a separate bank account with a scheduled bank for the purpose of this regulation. However, that committee recommended that in case the IBBI maintains a corporate liquidation account, and then the money will be routed to public accounts of India, and whenever there is a claimant, the claimant will come. The claimant will first approach IBBI, then IBBI will verify, and then will send a request to Public Accounts Department of Government of India, and then the funds will be released from that department. So therefore, it was recommended by that committee that the public accounts of India, this is not, this should not be part of the process. So finally, this proviso is deleted. So now the IBBI is maintaining corporate liquidation account, and any request which is coming, it will be handled and it will be disposed of by IBBI only, without going to the Public Accounts Department of Government of India. So this has been done in the liquidation process as well as in the voluntary liquidation process. Both has been done. So this is significant only because this will in fact reduce one step. This will reduce one step. Now, another requirement which has been added for the liquidator by adding Regulation 47 capital B, that now, as in the case of CIRP 1 to CIRP 8, in this particular liquidation process is also liquidation 1, LIQ 1, LIQ 2, LIQ 3, and LIQ 4. The forms has been introduced. So in these forms, when we see the LIQ1, liquidation 1, I would call it as liquidation 1, as in the other case we call it CIRP 1. I will call it as liquidation 1, liquidation 2, liquidation 3, liquidation 4. So the liquidation 1 is required to be submitted only once, and that is on or before 10th day of the subsequent month after the public announcement has been made. So once that is done, then subsequently liquidation 2 will start. And in the liquidation 2, the information regarding public announcement, regarding valuation, sale, litigation, avoidance transactions, meetings of the SEC, receipt and payment, everything will be included in liquidation 2. All these forms will be filed online. In case not filed within time, 500 rupees will be the penalty. It will be a late filing fee. I will not call it a penalty, late filing fee. However, this liquidation 2 form will be filed every month. Every month, not every month, every quarter. After the progress report is submitted. After we submit progress report, then we submit liquidation 2 form. So this will continue till we have filed the dissolution application to NCLT. And once we have filed the dissolution application to NCLT, then every month we have to file this liquidation 3 till the time the dissolution order is not passed. And the liquidation 4 form is required only once when the dissolution order is passed. Let's understand again. Liquidation 1 is required only first time and not the second time. Liquidation 2 is required quarterly till the time the dissolution application is submitted. Liquidation 3 is required monthly after the dissolution application is submitted to NCLT until it is approved. And once the application is approved, then only the last form is submitted and the liquidation process is closed. So this is an additional work. However, it is good. It is good that the date is 10th. The date is 10th for 10th of every month, 10th of every subsequent quarter. That is something which is important because see, we are filing the quarterly returns on the 15th of the next quarter. So that means for the return that we are going to file for March 25 on 15th of April. So the next month, 10th May would be the last date for filing liquidation 2. 10th day, that will be the date for filing the liquidation 2. So that's what is the amendment. So I think this is all very clear. It has to be filed. And in case the liquidator is not filing all these forms regularly, IBBI and the IPA may take some actions against the liquidator, including disciplinary action. And so that is something which is like important for all, that it has to be done. There is a change in the mode of sale also. The mode of sale is also changed, and the earlier position was that the 14 days time was given to the eligibility prospective bidder, and now the 7 days at least will be given for the inspection. Now the new clause which says the first of all 35 days is the total process time. The liquidator shall provide the prospective bidders access to the assets under auction to facilitate their inspection and due diligence. So the prospective bidder will get a full 35 days after the public notice After he submits the expression of interest, he will have the access to the assets and he can do the due diligence. And then the clause 5A says the public notice shall state that the prospective bidders shall submit an undertaking that they do not suffer from any ineligibility under section 29A of the code to the extent applicable, and that if found ineligible at any stage, the earnest money deposit shall be forfeited. So this is a good development. This is a good amendment. Why? Otherwise, the liquidator was under difficulty because in case there are 10 expression of interest, the liquidator will have to make them qualified by having a eligibility test under section 29A. Then the other clauses are also mentioned, which is in the amended regulations now. Within 3 days after the bidding is complete, within 3 days of declaring the highest bidder, the liquidator shall conduct due diligence and verify the eligibility of the highest bidder. Liquidator will only do the diligence for the highest bidder, and then the liquidator will present the result, details of the highest bidder, along with the due diligence conducted by him before the committee, before the consultation committee. And then the liquidator shall declare the highest bidder as successful bidder or reject such bid after consultation of the committee if the bidder is found ineligible. Then the earnest money deposited by him shall be forfeited, and the liquidator will approach the second highest and will do the same process again. Will do this 29A for the second highest, will take it before the consultation committee. If approved, then it will be considered a successful bidder. If not approved, then the liquidator will go to the third one. So that is the process that has now been defined by IBBI in the liquidation process regulations. That's good. And this amendment, which is the Schedule 2 Form Part 1, this is only for claiming the undistributed proceeds. There is some change in the wordings because of the change that we have seen, that the process will not go to public accounts of India. So therefore, there is some change in the paragraphs and the some kind of headings of the form. Now we also have the voluntary liquidation, which the amendment is the same regarding the corporate voluntary liquidation account, as the public accounts of India word has been removed. So therefore, the IBBI will maintain this account, and also Regulation 41 has been inserted regarding filing of forms. And in case we see again, VL1, VL2, VL3, VL4 has been inserted. VL1 is regarding the corporate person details of the process that is required to be submitted only once. Then VL2, this form is required to be submitted every month, and it will give the details of the meetings of the contributories with the reasons for delay in the process, details of the replacement of the liquidator. So this will be submitted every month. Then the VL3, this form is also required every month because details of the dissolution application. Once the dissolution application is made, details of unclaimed proceeds, the details of realizations and the distribution made to stakeholders, details of pending litigation, detection of fraud, etc. This also will be required to be submitted every month. And the last, when the dissolution application is submitted, that is required only once. So in voluntary liquidation, since there is no requirement of submission of quarterly progress report NCLT, so the VL2 is required every month, VL3 is required every month, but in liquidation, the liquidation 2 is required every quarter, consequent to filing of the quarterly report. So this is also again having a 500 rupees as the late filing fee. In case there is a continuous delay from the liquidator, then the IBBI can take other actions, and also filing inaccurate particulars, or also kind of again and again updating or correcting. Any updation or correction will also attract a penalty of 500 rupees each filing. Again, dividend distribution claim, that has also been amended. Quickly, we will take you through the grievance and complaint handling procedure regulations. And it was so far it was mentioned in the regulation that the complaint can be filed within 45 days of the occurrence of the cause of action for the grievance or the complaint, provided that a grievance or a complaint may be filed after the aforesaid period if there are sufficient reasons justifying the delay, but such period shall not exceed 30 days. Now, the amendment is such period shall not exceed 30 days from the date of closure of all proceedings relating to the process under the code before the adjudicating authority, before the appellate authority, before the High Court, or before the Supreme Court, as the case may be. No, it is again based on some uh, observations of the court. The court might have said that the period of complaint or grievance against the RP, against the service provider, that has to be filed within 45 days of the occurrence of that cause of action. But now, in various cases, the NCLT is also observing something against the service providers, may it be insolvency professionals, or the liquidator, but the regulations are not permitting to start any action against the insolvency professionals after 45 days of cause of action. However, now it has been extended 30 days from the date of closure of all proceedings. 30 days from the date of all proceedings. So this is not related to, in case there is anything which is mentioned in the order of adjudicating authority, appellate authority, High Court or Supreme Court, it would be applicable to that only. Probably I would not think that any person can submit a grievance and complaint even after 30 days or after 45 days. But this particular assumption is only but shall not exceed 30 days from the date of closure of all proceedings relating to the process under the code before the adjudicating authority. So any observation from court, NCLT, NCLAT, High Court, Supreme Court, for that observation, the period of 30 days is extended. But to my understanding, for any grievance to any other person, it is still restricted to 45 days and then extendable by another 30 days uh, from the occurrence of cause of action. From the occurrence of cause of action. That's what is my understanding. But I still feel that this may even lead to some kind of confusion and also litigation, because it is not clear that this extension is only for court observation or it is for everyone. So this should be kind of said. Now, there is an amendment which is notified in Inspection and Investigation Amendment Regulations, and that is the definition of disciplinary committee. In the definition of disciplinary committee, as per the Regulation 2, means a committee of whole-time members constituted by the board under subsection 1 of section 230 of the code, provided that the whole-time members in the disciplinary committee shall not be associated with the investigation or inspection. So this is what is the definition of disciplinary committee. And when we see this amendment, it says that the word associated, as mentioned here, is not completely defined. So therefore, the IBBI has now defined the word associated, and it says associated shall mean involvement in the conduct of investigation or inspection or consideration of the investigation or inspection report or issuance of show cause notice. This is where it will be considered as associated, and so that it is also kind of plugging a loophole, because this was a loophole which was being used by some insolvency professionals, that the person who actually has been appointed as the DC in his case is also heading the investigation department. So therefore, this associated word has been brought in to plug that gap. So associated is now clear, and this was required because this was ambiguous, like it was kind of. Now I'm coming to the IBPI Model Bylaws and Governing Board of Insolvency Professional Agencies Amendment Regulations 25 in schedule part 6. The heading is the professional membership. Then Regulation 12A says registration of professional members, and it also says that an application for issue or renewal of AFA, authorization for assignment, shall be in such form, manner, and with such fee as may be provided by the agency. The IPA will provide. Provided that an application for renewal of an AFA shall be made any time before the date of expiry of the authorization, but not earlier than 45 days before the date of expiry of the authorization. So in the last amendment, instead of issuing AFA for 6 months, now the IP has started issuing the AFA for 1 year. So therefore, this 45 days, the earlier 45 days, it should be increased to 90 days, because in case my AFA is expiring on, say, 31st March 25, then I can apply for renewal 90 days before my date of expiry. And also there was a provision that in case your AFA is not rejected or not renewed within 15 days, then it will be considered as renewed. That 15 days has also been increased to 90 days. So you can make an application before 90 days, and then you can expect that it will be. So virtually, what is now that AFA should be applied immediately on the 90th day, when there is only 90 days are left for your renewal, it should be applied. And in case it would not be given or rejected by IPA, then it will automatically be considered as renewed. So this is also a kind of facilitation. So then, like in the, as I said, in this IU, there are a lot of amendments in the IU. And also there are the huge, it has been proposed something which is in the discussion paper. So the discussion paper, which was released on 4th, that we would be covering in the next webinar. And we also will be discussing the changes in the insolvency, so information utilities. So today we could do this only, and we tried our best to cover as much as possible. However, the discussion papers and the information utilities, that we would be covering in the next episode, which will be our 149th episode. We are not taking questions today, and it is only because the time is not permitting us, and also the time has to be essence, because we actually keep it for 1 hour, so we would keep it for 1 hour. Questions and answers that we will keep for the next session. So we are concluding it. Thank you very much. It is our way of learning. Thank you.